a big thanks to Mark and to President Zapatero for inviting me to address this August Assembly, and also a special thank for accommodating my issue with a flight departure this afternoon. As Mark said, I'm the president of the so-called Rwanda Tribunal, the UNICTR, and we are concluding our work after 21 years of operation on Monday with the delivery of our last appeals judgment, so I need to catch the flight and be there. I'm going to make 2 points in my presentation. The first one is that the prosecution of individuals for violations of international criminal law and international humanitarian law indeed does contribute to the process of reconciliation and peace building, although it can hardly be described as cultural diplomacy. And my second point is that the international courts, the international criminal courts, and today I will speak of my own court in particular, in addition actually has a lot of outreach and capacity building activities that falls squarely within the meaning of cultural diplomacy. To my first point, the core functions of the international criminal courts. The prosecution of crimes has traditionally been the prerogative and responsibility of states. We had the first international courts after the Second World War, the military tribunals in Nuremberg and in Tokyo, and following them and the establishment of the United Nations, work began to establish an international criminal court in parallel to the International Court of Justice that has existed since 1920-something. However, that work stalled because of the Cold War, which more or less paralyzed the UN for a number of years. The UN's charter doesn't say anything about creation of international courts, but in 1993, the UN Security Council decided to use its authority under Chapter 7 of the Charter, which authorizes the Security Council to take measures to create and maintain peace, to establish the International Criminal Court for the former Yugoslavia, the ICTY, and 1 year later, the International Criminal Court for Rwanda, ICTR, as I work for. And in doing so, the Security Council expressed the belief that international prosecutions would contribute to the process of reconciliation and building peace in the Great Lakes region. In that wording, choice of words, the Security Council expressed two things. First, the one was that international justice can contribute substantially to peace building and to reconciliation, but it cannot do so on its own. It can contribute, and it can contribute to a process. If nothing is done but prosecuting criminals, we would get nowhere. It takes the involvement of the parties in the past conflicts and the international community to address the underlying problems that caused the conflict and to create a just and fair society with equal opportunity for everybody irrespective of race, gender, and socioeconomic status. In that process, also the existence of an effective legal mechanism is very important. The ICTR was dealing with the genocide in Rwanda, so therefore we have primarily developed the jurisprudence on genocide. We were the first international tribunal to convict anyone for genocide and to interpret the Genocide Convention of 1948. We have also been very much involved in creating jurisprudence concerning sexual violence and gender-based violence in conflicts because of the sad fact that mass rapes were a sort of integral component of the genocidal campaign in Rwanda. So we were the first tribunal to define rape in context of a conflict, a much wider definition than the one we traditionally use in national law. We were the first tribunal to convict for rape as a means to commit genocide, war crimes, and crimes against humanity. And we have been so far the only tribunal to hold leaders responsible for the commission of genocide under the principle of extended liability for joint criminal enterprise. We held them legally and criminally responsible for launching the genocidal campaign with the knowledge that rape of women were likely to occur. So they were convicted for rape, although they hadn't had, to our knowledge at least, any physical contact with the victims. Because of the time constraints, I will go on to my next point, namely that the international courts do have a very important program of cultural diplomacy. The ICTR and the other international courts as well have engaged in a number of outreach and capacity building programs. It's limited by two factors. First, we can only engage in it to the extent that it doesn't affect the timely completion of our core work, our judicial functions. And secondly, we cannot use the UN budget for it. So we rely completely on voluntary contributions. And standing here today in Germany's capital, I would be remiss if I didn't use this opportunity to thank our most generous supporter, the German government, for their very extensive support to our outreach and capacity building programs. What we have done is focusing on education, not only of Rwandans, but of the whole African region and beyond on the work of the tribunal, the evolution of genocide and the lingering effects that genocide and mass violence can have on a community and its citizens. We opened an information center called the Umusanzu Biyunga Information Center, or Contribution to Reconciliation, in Kigali, and 10 additional provincial centers across Rwanda. And these information centers played a key role in bridging the information gap between the tribunal and the Rwandan population, especially because we were not based in Rwanda due to security concerns in 1994, but in neighboring Tanzania. And we provided members of the Rwandan judiciary, academics, students, researchers, and the public with access to a vast legal library, information materials on the work of the ICTR, trainings, and other library services. These information centers facilitated and improved relations between the tribunal and Rwanda, and possibly more importantly, enhanced the exchange of information and ideas and the collaboration between different cultures within Rwanda, a key function of cultural diplomacy. And in order to ensure that the affected communities not only understand the work of the tribunal, but also the ramification of the genocide and the lessons learned in our battle against impunity, many of our outreach programs have focused on education through mass media and other modes of communication, like the newly revamped ICTR website. And through the website and other interactive programs created by the tribunal, as well as the placement of a Rwandan journalist in Arusha, our seat in Tanzania, and assisting of the establishment of a news agency, the Hirondelle news agency, the tribunal ensured that our decisions, judgments, reports, lessons learned, and best practices manuals are widely available for public consumption. So the focus of education through mass media has allowed us to reach people from every corner of the globe and has further encouraged greater cultural dialogue, understanding, and trust in the hope of avoiding repeating mistakes of the past. We have also focused on raising awareness among the youth. In 2006, we began an awareness-raising campaign for Rwandan secondary school students on the mandate, relevance, and role of the ICTR, and on sensitization on the Rwandan genocide and lessons learned throughout the tribunal's existence. The campaign included genocide awareness, raising workshops, and the dissemination of information on mass atrocities and its precursors, such as hate speech and discrimination. These youth programs also included the distribution of copies of an ICTR cartoon book entitled, quote, 100 Days in the Land of Thousand Hills, end quote, which again was sponsored by the German government. And this cartoon book informs and teaches youth about genocide, the causes and dynamics, and the concept of never again becoming a reality. A total of 20,000 copies of the cartoon book were distributed to the primary and secondary schools in the Great Lakes region, and exhibitions and workshops regarding the ICTR's work were organized throughout Kenya, Tanzania, and Rwanda. Last year, the tribunal provided workshops that covered over 36 schools in various parts of Rwanda and included the participation of over 26,000 teachers and students. We often hear that the youth is our future, and in this regard, the tribunal has made concerted efforts to educate the youth throughout Africa and to promote the idea of cultural diplomacy until the ultimate goal of peace and stability is reached throughout the world. In addition, the ICTR has disseminated lessons learned and best practices manuals, including manuals on the referral of international cases to national jurisdictions, on the prosecution of sexual violence crimes, and on the tracking and arrest of fugitives. These manuals provide useful information to both international and domestic judicial institutions and ensure that the tribunal's work will continue to help future trials of international law long after the ICTR closes its doors. Further, we have accumulated expertise and know-how on the prosecution and administration of criminal justice, which we have shared with other East African countries and other national courts and regional courts in Africa, including the African Court of Human and People's Rights, which is also based in Arusha, Tanzania, and the ECOWAS Court, and as far as the Caribbean Court of Justice. So much about our capacity building and outreach programs. Then a third point, which I sort of was inspired to make yesterday, hearing Julie Mandusela's call for restorative justice. The ICC has a reparations fund, which maybe is not that effective so far because it's also based on voluntary contributions. The ad hoc tribunals, the ICT1, the ICTR, doesn't have reparations as part of their mandate. However, as part of our outreach programs, we have created medical clinics in Rwanda and clinics giving HIV treatment. We don't believe that a criminal court can actually effectively run a reparations project. We only see the tip of the iceberg, which passes through our court, and the need for reparation is much wider. And our operations are very fine-tuned to dealing with criminal cases, and is extremely expensive. But we do believe that there's a need for the creation of institutions that can deal with reparations. We made a plea to the UN Security Council in 2002 to set up a separate organ to deal with reparations for the victims of the Rwandan genocide. The call was never heard. I think the general attitude was that we already cost much more than they had anticipated, and so there was no political will to expand the expenditure. One of my first initiatives when I was elected president in 2012 was to reach out to the Victims and Survivors Organization in Rwanda to assist them with a project they had for the establishment of an organ which could deal with reparations. I managed to get the IOM, the International Organization of Migration, which has a special unit dealing with these issues, to agree to conduct a feasibility study, and also managed to persuade the Finnish government to support the work. And a report has actually been produced by IOM in cooperation with the Survivors Organization and the Rwandan government, and it describes the different options that you can give reparations, whether on an individual basis or on a community basis, and how to raise the funds for it. But somehow now, for a year's time, this report has been stalled because of some political issues in Rwanda that is outside our controls. But within the mandate, we have tried to do what was possible with respect to restorative justice. Those were my remarks. Thank you.
Thank you very much. We'd be happy to take one or two questions or comments for Judge Joensen. As always, if you could raise your hand and then briefly introduce yourself. Ladies first, and then we'll take one more. Please.
Thank you. Firstly, Judge Joensen, thank you for the great work that you're doing and for such an insightful presentation. Just two quick comments. The first one is on restorative justice. Clearly, the UN might have difficulty because the world has to generate funds for numerous causes, and at this stage it's really difficult to say which cause is more important than which one. What do you think about the possibility of institutions such as the ICD or any other exploring crowdfunding for victims of war, not just Rwanda, but just looking again of what has happened in the Arab world? I'm thinking about this. There was a little boy, I think it was in the UK. The story went viral on the internet. Was it UK or some other European country where a little boy took all his lunch money and said, okay, this money is going to refugees. And I think what was heartwarming was not the amount of the money. It was, here's a little Christian boy who's touched by what he sees and he's putting his lunch money into it. And just your thoughts on that possibility. The second issue is on these international criminal courts. I mean, I hope you saw this one coming. In my presentation recently in the UK, I had a lot of pushback on the issue of the ICC when I was arguing that Africa should stay in the ICC despite the difficulties, and until such time that maybe there's an alternative, or alternatively have it reformed. But one of the great grievances is lack of good faith. That when the ICC, that's not your court, that's not the Rwanda, then the more global ICC. When it was created, all countries came in good faith to create this court to ensure that there's accountability for war crimes and related crimes. And of course, there was an assumption that everyone who was involved in conceiving the court would subject themselves to its jurisdiction. Flip back to where we are now. Rome Statute was passed. Many African countries and other countries signed in good faith. But some of the key role players then didn't sign. And now, because of the nature of the UN Security Council, they have a say on how this court is run. And they have a say on who can be netted by this court, but their own activities are not subject to the jurisdiction of this court. And African leaders are then saying this is a huge grievance for them, it's lack of good faith. Again, I'm not arguing for Africa getting out of the court. I really think that it should stay there and we should reform it. But what do you say about that grievance? And if you agree, what is the way forward? Thank you.
About crowdfunding, I believe that was the way that Barack Obama got elected president of the US. He got $10 or $20 from 50 million people, and thereby could had a much larger budget than Hillary Clinton. So it could also work for a reparations mechanism. Your other comment that such a mechanism should not be limited to a special area as Rwanda. Of course, my court is dealing with Rwanda, so we can't go about, setting up mechanisms dealing with Myanmar or somewhere else. The problems with having institutions that have a too far mandate, and I also think that's a problem for the reparations fund that the ICC has, is that it becomes very bureaucratic. There will be no influence from the victims groups or the survivors groups, because if it's covering the whole world, who should we elect? So I think the future might be a sort of more concentrated reparation fund, but a means to get money into the fund could be the crowdfunding. I don't know if that's part of the study that IOM has made, because it's still classified, so I haven't seen it. But if it isn't, I will bring it up with IOM next time and mention you as the one who got the idea. About the ICC, my colleague from Uganda is representing the ICC and will make a presentation here later. But in the Kiswahili language, especially when it's spoken by us foreigners, you can't really hear the difference between ICTR and ICC. So I'm always confronted with questions about the ICC when I say that I'm from ICTR. So I sort of have a defense, so to say. There is an imbalance built into the ICC system, namely the link to the United Nations Security Council. ICC is a treaty-based organization, so primarily it can try cases that concerns the state parties, such as the one concerning the post-election in Kenya. It can do so on its own initiative, or it can deal with self-referrals from states. The vast majority of the cases that ICC is dealing with concerning Africa are self-referrals. So it's Uganda, Cote d'Ivoire, DRC, and Central African Republic who have referred cases to the ICTR. Now I make the same mistake as my Kiswahili colleagues, to the ICC, and you can't really blame the ICC for responding to the call to assist these countries. The other group is the cases that ICC initiate themselves against state parties, such as the one concerning the post-election in Kenya in 2007. But there the basis was actually a report which was produced by a Kenyan commission headed by Justice Waki. So I have difficult there to see that the ICC is sort of biased in any way when they actually rely on investigations carried out by the Kenyans themselves and very prominent Kenyans commission that was set up by the Kenyan parliament. And then we have the third group, namely that cases can be referred from the UN Security Council. And it is a problem because in the Security Council we have 5 permanent members who can veto any decision on substance, and certainly do it if it somehow affects themselves or allies, which is the reason why the ICC can't deal with the Syrian crisis, for instance. It's an argument that I often hear in Africa that here it's US, China, and Russia sit and decide on the prosecution of situations in other countries, why they themselves don't want to submit to the jurisdiction of the same court. It is a moral issue. But we can't force them into the ICC. As I said, it's a treaty-based organization, and the UN Charter doesn't provide for anything more than what they have done already with the establishment of the ad hoc tribunals. Maybe my colleague from Uganda can give a more extensive answer when she makes her presentation.
Well, thank you very much, Judge Joensen, for the lecture as well as for the response to those very detailed questions. I think it was plenty to take a few questions, but I think those were so intensive, I think we will need to conclude on that. But we really appreciate, once again, your generosity in coming and making the trip to Berlin, and we look forward, hopefully, to continuing our collaboration that we've started today. So if we could please extend our sincere gratitude to the Honorable Judge Joensen. Thank you.